Rochester of the Appellate Division, Fourth Department. Hear ye, hear ye, hear ye. All persons having business before this court, regarding any of the attendance shall be heard.
Thank you. Please be seated. The first case on the calendar for oral argument this morning is People versus Burns, 618, Joshua Burns. Good morning.
Good morning, Your Honor. If it please the court, Shirley Gorman for Joshua Burns. With respect to juror number one, ironically the very first juror in the whole trial, when the court asked jurors if there was any reason that they were concerned about serving, she indicated, "I would prefer to be studying, but I understand my obligation." The DA then asked a question, but phrased it in such a way that every single one of us would have agreed we couldn't give undivided attention. He said, "We need 100% of your attention. Can you give us undivided attention?" He basically indicated to her, is there any distraction that will impact? As this court knows from the decision in Oskonek from June, there is a distraction element for every human being sitting in the jury. But this juror in particular, because she noted repeatedly this duty, this obligation to sit, she recognized that she would pay attention when needed. The defense attorney asked, when a matter deserves attention, can you pay attention to what was said from the stand? Unequivocally, yes. Can you be a good juror? Yes. She thought about the question about being a good juror. She just didn't answer because that's what was expected of her.
But she did clarify a little bit later. She was worried if the trial went in later in the week, that would cause problems for her because she had a test of some sort coming up. It hasn't, we have held many times, the Court of Appeals has reversed us many times saying, if it's anywhere close, if it's a close call, whether somebody can be impartial or not, the trial court should err on the side of caution and get rid of that prospective juror. The worst thing that is happening in that situation is the trial judge is replacing one impartial juror with another. That seems to be what the trial judge did here. It was a close call. He erred on the side of caution. That's not the right course of action, according to you.
But the words in the statute and in the case law is fair and impartial. It has to get to the point, and this court cited De Fritas, which is the case I cited, it has to get to the point where you can't deliberate fairly and impartially based on the evidence. And she never indicated that was the point. There are peremptory challenges. This was the first juror. The people had 20 peremptories. That's the purpose. If you have a concern about someone that doesn't reach to fair and impartial, you excuse that person with a peremptory. And because this wasn't a bias issue, clearly if you have a bias issue, and most of the cases arise from that, then you want to go overboard to make sure that bias doesn't slip in. But this wasn't that. This was a distraction issue, which should be treated differently than the bias.
We understand. Do you wish to argue any of the other points in your brief?
Yes. With respect to the the response to the jury note, the jury asked, when someone shoots to cause harm but not death, is it murder? Why couldn't the court just say no? The answer to that is not ambiguous. It's no. It's manslaughter in the first degree, which you didn't receive as an instruction, but the court instead repeated all the jury instructions, included the section 20 accomplice liability, and gave this jury the same instructions they'd received in the beginning. Case law indicates that if That's all you do, and there was some confusion in the note, there should be an answer to the question.
Wasn't the answer no self-evident from the instructions?
I don't think so, because clearly they were concerned about intent, and they were not giving, and as the court knows, I'm arguing that manslaughter first should have been given as an instruction, because there was a reasonable view of the evidence. This jury was looking at it. What if, and we don't know whether they were looking at it as if my client were the perpetrator or the accomplice, but they were looking at what if he didn't really intend to kill? At least somebody in that room was concerned that there was insufficient proof of intent to kill. So they were looking at intent to cause harm, intended to cause somebody injury, not realizing the kind of damage you might do with this sawed-off shotgun. And so that instruction...
Looking at the facts and circumstances there with reference to that lesser included charge, I mean, we have a situation where the defendant shot the victim in the face with a shotgun.
He ended up shot in the face, but there's no way to tell from the logistics of this case whether that was what was intended when the shot went off. And as the court knows from my brief...
Was it a close range situation too?
It's less than 6 feet is all the medical examiner could say. The cases that have held, including one in this court, that deal with close contact have been very close, have been supplemented by some kind of threats or something.
Aren't those one bullet cases though, single shot? It would seem to me it's worse for your client on intent, the fact that it's a shotgun, where pellets are going everywhere from 6 feet away. It's kind of obvious that you're going to strike a vital organ from that close with a shotgun.
Well, that's assuming that the person using the shotgun understands that's the impact. It could seem less dangerous because it isn't one bullet, it's a lot of little things. And of course, this was virtually instantaneous from when Mr. Porter walked in the door. This wasn't sitting there aiming. You've got Mr. Porter walking in the door, and then almost immediately, the co-defendant, whom I submit had to be the shooter in terms of the way he came out, when he came out, the fact that he was not injured, which is why I believe the verdict is against the weight of the evidence, why I've argued that. So when you have a situation like that, and if you have someone who saw the gun, if he saw the gun, his reaction could have been to avoid it, putting his face more in the line of fire than the shot might have gone over him.
We understand.
Otherwise.
Your argument is that there might have been some ducking, might have been aiming at the stomach area and the guy ducking in the face. We understand all that. Any other issues you wish to argue today?
I would just like to say, with respect to weight of the evidence, that the court should look at evidence that came in that I have argued should not have come in. The jail call, so ambiguous. The firing print expert saying these are the exact same impressions, and the DA arguing this is the calling card, arguing that the jail call was an admission, and the way in which it was used in summation, the court can see how vital that was to their case. And I would submit that the jail call was so ambiguous, the failure to give the manslaughter charge, these errors compound and resulted in a verdict that was against the weight of the evidence.
Thank you.
Thank you, Your Honor.
Good morning, Your Honor. Scott Miles on behalf of the people. In regards to the jury selection issue, this is an excellent example of why trial judges are granted the discretion that they're granted. And this was a proper exercise of that discretion in this case. As Justice Lindley correctly observed, even in an ambiguous case, and at best this situation was ambiguous as to this juror's qualification, the trial judge is there to use that discretion in such ambiguous cases, and in this case, based on the juror's responses, this was a proper exercise of discretion. In regards to the manslaughter charge, again, as was noted by several justices, there was no intent to cause serious physical injury here. There was intent to cause death. There is.
Well, what if the defendant was not the shooter, which seems entirely plausible given the order in which they tumbled out of that door? Ms. Gorman makes a legitimate point that the co-defendant followed the victim. Co-defendant wasn't shot. Your client, or her client, was behind them. So if the defendant were not the shooter, which is plausible, then the intent argument becomes a little bit stronger. If you shoot somebody in the face with a shotgun from 6 feet away, you intend to probably kill that person.
Correct.
But if you're acting in, they have to share the intent. And so it's a little harder for the people here to prove that the defendant who didn't shoot perhaps shared that intent.
Well, I think if you look at the other evidence given, the defendant's statements prior to the shooting, that he had this animosity toward the victim, that he intended to get him, the statements in the jail call, the statements to the other witness after the shooting that, in fact, that they had used the shotgun to kill someone. Taking all of that into account, plus the fact that if you watch the video when the co-defendant and the defendant come out of the door, you cannot see what the defendant has in his hand, but he clearly looks to be holding something in his hand, something that the people presented to the jury, and I would argue again, was consistent with a shotgun.
It looked like, very unclear, but it looked like the co-defendant, based on positioning, was more likely the shooter. He turns around to go back to get something. I think it looks like he dropped his gun and the defendant picked it up. That's a plausible we don't know what happened. No one in this courtroom does, but that's a reasonable explanation of what happened there, is it not?
Again, given all of the evidence, the statements, the video, all of the evidence, I don't believe it is a reasonable interpretation of what happened. The events took place so quickly. The co-defendant comes out of the door before the victim has even hit the ground out of the doorway. It's almost instantaneous.
So how does the co-defendant not get shot, struck with at least one stray pellet, if the defendant is the shooter? How is he unscathed?
From other evidence and testimony, I believe the layout of inside the doorway, there's a stairwell on one side. And again, given the trajectory and the wounds to the victim, I think it's a likely interpretation that the shooter was standing on those stairs. And if the co-defendant, who was not the shooter, was standing perhaps beside the stairs or closer to the doorway, he would have been the first one out after the victim stumbled out, which is exactly what happened. And if the defendant, who was the shooter, was standing on the stairs, it would have taken him that extra second or two to come out the doorway. And again, that's exactly what's reflected in the video.
Anything further?
Unless there are any other questions?
Hearing none, thank you. Case number 619, People versus Cepeda. The defendant has submitted.
Yes, Your Honor, in light of the submission, I'm here to answer any questions. If there's none, I'll rest on our brief.
Hearing none, thank you. 620, People, State of New York versus Wagner. That's over the term. 621 is submitted. 622 is People versus
621, do we have Nancy Gilligan here?
621 is, I have it submitted. Ms. Gilligan is here?
No, Judge, that's submitted.
Okay.
Yeah, I'm just looking at her.
Yeah, no
Just
problem.
10 minutes, okay, sorry.
22 is People versus Newlander. Good morning.
Good morning. May it please the court. My name is Alexandra Shapiro, and I represent appellant Robert Newlander. I'd like to briefly address our weight argument and then turn to the missing witness instruction and the improper cross-examination of the principal defense expert. Our briefs detail why the verdict was against the weight of the evidence and why there's no way to rule out a hypothesis of innocence, so I just want to highlight a few key points. First, unlike at the first trial, the defense at the second trial was specifically laser-focused on the scientific evidence showing that the injury that caused Leslie Newlander's death was likely due to an accidental fall. The defense called 3 well-credentialed experts who did not testify at the first trial, who analyzed the injury in extensive detail to support that conclusion.
Are you arguing this in context of the weight issue or the sufficiency?
The weight, Your Honor.
Thank you.
And the principal reason that it was likely due to an accidental fall was the contra coup injury. As these experts explained, and the people's experts did not dispute, a contra coup injury is the signature of a fall. And indeed, none of the experts who testified had ever encountered a situation in which an assault caused a contra coup injury like the one that Leslie Newlander suffered. In addition, the people conceded, both to the jury and here on appeal in their brief, that an accidental fall can cause an injury similar to the one that Leslie sustained. If there are no questions on that, I'll turn to the missing witness instruction. All of
What is the more critical error from your perspective? That is the giving of one at all, or the giving of one with this phraseology?
well,
If you can do a hierarchy between the two, and if you can't, that's fine.
I would say that we would start with the proposition that the instruction shouldn't have been given at all in the particular context of this case because of the nature of the defense case. People v. Paler establishes that the only proper inference that can be drawn against a defendant in a case in which an instruction like this is appropriate against a defendant is one that allows the jury to, that has a presumption that there's a convergence between the material knowledge of the witness and the testimony presented by the defense. And in this case, there was no such testimony because the defense case was focused on the scientific evidence, and to the extent some very limited fact evidence was presented by the defense, it did not concern the events as to which, the events of the morning of the injury, and that was the only area that Jenna had
You read
non-cumulative.
Paler to have two requirements. One is that the missing witness's testimony has to relate to the evidence that the defendant submitted, correct?
Correct.
And also, the missing witness, the testimony, any inference has to be with respect to knowledge that she has.
Correct.
The first proposition, that there has to be a nexus, if you will, between the missing witness's testimony and the defendant's evidence. I don't see that in Paler. Where in Paler do you get that in? Are there any other cases that, I think what you say makes sense, okay? I think if I were drawing on a blank slate, I think that's a legitimate, good rule, but I don't see it articulated by the Court of Appeals.
I think it's implicit in the court's holding, because what the court is saying is that the only proper inference that can be drawn is that if the witness had been called, she would not have supported the defense testimony on the issue of which she possessed knowledge. And I think it's implicit in that phraseology that there has to be defense testimony on the issue of which the defendant possessed knowledge. In addition, as we point out in the briefs, there are, in the few cases in which a missing witness instruction against a defendant have been upheld, they have all involved situations where there was a convergence between the defense testimony and the witness's non-cumulative material knowledge. That neither this court nor the Court of Appeals nor any other appellate division, as far as we're aware, has ever upheld a missing witness instruction against a defendant in a case like this, where the defense presented no testimony on the issue of which the uncalled witness had material non-cumulative knowledge.
Well, go ahead.
No, you first, please.
The way the prosecution looks at it is that she did have material knowledge on a material issue for which the experts testified. For example, rigor mortis, when did that set in? That was an issue debated by the experts, and an issue here. Her testimony at the first trial was that the body was stiff when she helped to move it. And wouldn't that alone, there's others, whether there was blood in the bedroom, whether when she made that 911 call, she said, I see there's blood everywhere. Was there blood in the bedroom before the mother was moved? various issues along those lines. Isn't that a nexus?
Well,
Assuming
no.
what is required?
I would say two things. Number one, there are no cases in which an instruction like this has been upheld where the defense only presented expert testimony. And number two, the defense presented no fact witness who testified when the blood was deposited in the different
But
areas.
they called fact witnesses, the sister, the son, the friend they had dinner with the night before, a lot of fact witnesses that the daughter has knowledge about.
Well, those witnesses, none of them were present in the residence on the morning of Leslie's death.
Correct.
And none of them testified about anything as to which Jenna had non-cumulative knowledge. I mean, that they gave limited testimony about the nature of the Newlanders' relationship, Leslie's history of vertigo, things like that, and the dinner the night before. There was no suggestion that Jenna had any non-cumulative knowledge. In addition, and this gets to Justice Kern's second point, question about, our two arguments. We have also argued that the scope of the particular instruction given here was vastly overbroad because it didn't focus the jury's attention on these matters as to which the defendant had presented testimony. Instead, it was broadly worded.
But following up on the Justice Presiding's questions, you would agree that if the court was going to give a missing witness charge over your objection, if the court had narrowed it to the point of that Jenna would have given testimony favorable to the defense on rigor mortis or blood stains certain portions of the carpet, etc., that would have been better than what you've got. Is that your argument?
Well, that's not our argument, because we believe that it was improper to give an instruction at all because those
I understand
points
that,
were not
Counselor. Forgive me, I
addressed by
understand.
other fact witnesses.
Forgive me for talking over you a bit. I understand that you objected. I built
Okay.
that into my question. I'm beyond that, just for the sake of the next issue that you're identifying, the overbreadth alleged of the instruction. If the court had narrowed it to the issues that the Justice Presiding indicated, that would have been better, albeit over your objection, than what you got in terms of the overbreadth of the issue identified by the court in its instruction. Am I close?
It certainly would not have been nearly as damaging or prejudicial or unfair.
Okay, so on the overbreadth, as I call it, but did you object to that? Because when I look at the proposed, I'm sorry, I took a breath, but when I look at the charge that you proposed in your letter to the court, you incorporated that issue into your proposed charge, exactly as phrased, as I understand it, by the people. Now, I don't see the people arguing the absence of preservation, but we still have to look at it, as I understand it. So the question, did you preserve any objection to the overbreadth of the issue as framed by the court and the prosecution?
We did, Your Honor. First of all, we made clear, as I think Your Honor understands, that we objected to the charge at all, and we repeated that and indicated that the proposal we made was sort of, in effect, under protest. But if you look at the proposal we made, we deleted all the preamble which directs the jury's attention to the fact that the central issue in the case is the manner in which Leslie Newlander sustained her injuries, and the fact that the jury has heard evidence that Jenna Newlander was present in the residence the morning of the death, and that she placed phone calls to 911 from the residence.
But
So
your client's proposed charge, granted, it was only if the court was going to give it over objection, but that inference that the court told the jury they may draw is word for word from your proposed charge.
I understand that, but first of all, it was not really our proposed charge, and I want to take things back to the first argument, because I think it's critical here. Our point is that there was no effective way to give an instruction that would comply with Paler in the circumstances of this case, because of the fact that the defense deliberately made a decision to focus on scientific evidence, and unlike in the first trial, not to present a defense based on things like the 911 calls or the other things that the people point to in their brief, the steam shower and so forth.
Counselor, in the cover letter to Judge Miller, when the charge was presented, on behalf of the defense, the request was for a shorter and more to the point charge, wasn't it?
It was, but it wasn't for the charge that was given. And we made clear that we objected to, among other things,
But the point, the proposition to Judge Miller was, we want to keep this really short, and now because it's short, it looks overbroad, doesn't it?
No, I don't agree with that, Your Honor, respectfully. I think the reason it's overbroad is because it directs the jurors' attention to drawing an inference that goes to the central issue in the case, which is an issue as to which Jenna did not have knowledge. She was not present when Leslie Newlander was injured. And on all of the other cases in which appellate courts have upheld these types of instructions, you can look at each of them. The instruction directs the jury's attention to specific testimony.
So how should this one have been written in retrospect to be permissible? Let's assume that the charge should have been given in the first place, which you dispute. Assuming arguendo that the charge should have been given, what should the court have read to the jury as an instruction there?
I think the court could have, if you put aside the cumulative aspect of this testimony, the court could have given an instruction that that from the failure to call Jenna, the jury could have drawn an inference that her testimony would not have corroborated the testimony of other witnesses as to the Newlanders' relationship or the events of the night before, or
It's a
Leslie's
long list
vertigo.
of things. Vertigo and their harmonious relationship or lack thereof. It's been a long list of things, right? Blood in the room, how about that? If they can infer that there was blood in the bedroom before the victim was moved in there?
I don't think
allegedly?
so, Your Honor, because it was the people and not Dr. Newlander who injected that issue into the case by introducing the 911 tape.
Well, Counselor, in any event, it's the people's proposed charge. You're not there to disserve your client by proposing other options for how it could be done. Here, the people have proposed the issue as stated. You have objected, and then there's a question perhaps about whether or not you preserve the objection vis-a-vis the overbreadth. But I'm looking at the letter at page 2566 of the appendix. It might be preserved, and the people don't argue lack of preservation on overbreadth. So your point, I would think, would be whatever the sub-issues might be that might have been more narrowly tailored, it makes no difference to us because it wasn't our burden to suggest them, and it might have been a disservice to your client to do so.
Exactly, Your Honor. I agree with
Do you wish to be heard on the Dr. Arden examination?
Yes, if I could just spend whatever the remainder of my time is, I'm not sure how much I have left. That was another way in which the trial was fundamentally unfair. Dr. Arden was the defense's principal and most important witness, and the DA engaged in a pattern of improper cross-examination that most blatantly the false accusation that Dr. Arden had been found guilty of sexual harassment, which was clearly in bad faith. There weren't even allegations to that effect. Second, he painted him as an ally of child murderers with a series of repeated questions about prior testimony in child death cases, including a number of references to the number of people experts on the other side. Some of these questions were questions in which the judge repeatedly sustained objections, and yet the prosecutor continued and asked essentially the same question again, turning to another case. And then finally, there were repeated instances in which the prosecutor engaged in blatantly inappropriate summation-style arguments, talking about other evidence in the case, making sarcastic commentary, and so forth.
But Counselor, the court did sustain the objections, correct?
The courts-
And gave limiting instructions?
The court sustained some objections, but as as we've cited a couple of cases in our brief, including Alisea and several others, in which courts have held that where a prosecutor blatantly blows by sustained objections and continues asking inappropriate questions, that can constitute misconduct that requires reversal.
Okay, but let me ask you this question. He used the words guilty, which was improper, okay? But there was also, wasn't there a good faith basis for saying that this witness had been found, that there were allegations of sexual harassment by this witness?
Actually, there weren't, Your Honor. Respectfully, first of all, the DA waived this 80-page report. There was nothing in the report that corroborated that. The trial court mentioned a Washington Post article, but the article contained allegations about operational and administrative problems in the office and allegations that Dr. Arden had belittled female employees, not that he had sexually harassed them. So that was just simply improper.
All right,
Thank
thank you,
you.
counsel, appreciate it.
Morning, Honors. Brad Osler for the people. I'll start in with the weight briefly, and I think the reason that the defense had a laser focus, to use their term, on the forensic evidence here was because or I shouldn't say forensic evidence, the nature of the injury is because the rest of the physical evidence in the bedroom spoke clearly to much more than a simple fall having occurred.
There was more evidence at the second trial, would you say, than against the defendant? There was tissue found on the wall that was, after the first trial for some reason, believe it or not, more evidence that the people presented second time around than the first time?
Correct, yes. The piece of tissue on the headboard, yeah.
The first appeal here, the different panel, found no problem with the weight of the evidence.
Correct.
Do you wish to address the missing witness?
Yes, I'll move right on to that, and I think...
Mr. Osler, let me get right to my key question on the preservation issue. Jumping to the sort of the end of the argument, perhaps, with respect to the argument presented by the defense as to the alleged overbreadth of the issue that the CJI, the court, and the prosecution all felt needed to be identified with respect to the charge, right?
Yes.
Do I read your brief correctly that you make no argument that that objection to the overbreadth, as articulated in the brief, is unpreserved?
No, that is correct.
So there's nothing in your brief that says it's unpreserved?
Correct.
So you think it's preserved?
I think the dispute with respect to the whether to give the charge at all, and then really to, I think, closely tied in with that is the nature of the charge or the breadth of it.
Was that a yes?
Yes.
They're both preserved?
I think that, I don't think it would be possible to separate those two in this.
You're not arguing that there's a waiver because the court on the breadth gave the defendant exactly what he asked for?
Well, I guess I don't, I wouldn't want to quote the record without seeing the transcript and the requested, I suppose,
Right.
alternate charge, but.
Do you think, assuming that there needed to be a link between the missing witness's testimony and the evidence submitted by the defendant, was there such a link here?
I would first say I'm not convinced that there has to be a direct link in the way that the defense suggests, that they have to present a witness with factual testimony such that this type of charge could then apply.
Well, let's suppose I'm charged with assault and I deny it. There was a friend of mine at the assault, at the alleged fight. I call at witness as a defendant. The only witness I call is a medical expert to dispute the level of injury. To say it wasn't serious physical injury, it was just physical injury, or it wasn't even physical injury, whatever. It's the only witness I call. And my friend doesn't testify who was there, has material knowledge. Can the people get a missing witness charge for my friend against me?
Based on the language of the Court of Appeals cases that I read as controlling, I don't see them as imposing that restriction. However, I will grant you the benefit of the doubt, Your Honor.
I'd be surprised if that case were presented the courts would go your way on that, some courts would go your way on that issue.
Sure, and
We're not presented with that here.
And we'll go down that path a little further, though. At least in this case, there was presentation by the defense of testimony that merits this charge. And the reason for that is because each of their experts, much as the people's experts did, reviewed the whole entire case file. Now, that included the defendant's interview, the analysis of the scene, photographs of the scene. I think the most relevant portion, though, and what makes this the charge appropriate is because the defense witnesses knew about the characteristics of the scene. They knew about the blood staining throughout the bathroom and bedroom. They knew about the blood splatter. They knew about the tissue on the headboard. In contesting their belief on manner of death, it's sort of it seems illogical to me to separate the characteristics of the scene from the ultimate conclusion. To do that would be, I think I used the word myopic in the brief, and that's what it would be. Our experts, the people's experts, reviewed the full circumstances of the scene, and from that review concluded that there was a murder. To not do that is just ignoring the circumstances. Now, in contesting the people's evidence, the defense experts acknowledged that they reviewed all of the relevant documentation that was collected, photographs, what have you. And challenging that is presentation of evidence in itself. The defense case in trying to establish that there was simply a fall in the shower and nothing else, it necessarily relies on all of that scene evidence. And so then someone who exists and is a factual witness and could speak to that very scene, most notably the blood spatter throughout the bedroom, to then effectively exercise, I guess, selective silence and not call that witness, I think is directly what this charge is addressing. And I don't think in this particular case, because while the ultimate question is, was there a fall versus some sort of attack or a fall and an additional attack, whatever the case may be, we can't separate that ultimate question from the viewing of blood, say, throughout the bedroom, or staining on the carpet, or tissue on the bed. And those are things that Jenna could have certainly provided the jury some information about. She, after all, did walk through the bedroom to supposedly find her mother and her father in the bathroom. So to say that she doesn't have, to say that the missing witness charge can't encompass her simply because they didn't have another, I don't know, physical eyewitness, say in your assault example, for instance, is, I think, reading the circumstances where a missing witness charge could be applied far too narrowly.
Anything further?
Judge, I'll just note that the missing witness charge, I think the one final backdrop that's important is that obviously charging the jury is a discretionary decision by the court. And to find reversible error in that, I think you'd have to find that single charge, especially given that in following the pattern instructions of the CJI, cautions the jury that it's only an inference that they may make, they need not make, and then clarifying that charge that it is still the jury's role to actually make that ultimate determination of guilt. Did you argue that it was harmless error in your brief? We did not, no. But I think it would be I can't see how it would be an abuse of discretion to issue this charge, especially in light of the amount of testimony and length of the trial.
It's, in your view, it's not harmless error, assuming error because the proof of guilt is not overwhelming?
In my view, it's not harmless error because it was not error.
Right, but you just asked you, are you arguing in the alternative harmless error, and you said no.
Oh, I mean, I would argue that in the alternative, and I think the overwhelming evidence is simply the fact that.
Didn't you just say no to that question?
Well, we didn't argue it, but if you're asking me if I would agree, I would.
Sorry, but in fairness, Mr. Oster, I did ask you whether it's in your brief. I didn't see it in your brief, but if I read it too quickly, maybe I.
No, I don't believe I put it in the brief.
And that might be for some a surprising omission in this situation that you didn't argue harmless error, but now given the opportunity, that's what you're suggesting.
I mean, I think if the court was inclined to find that, I would agree, but would say that I think there is an overwhelming evidence that was presented in, essentially in the bedroom scene.
Thank you.
Thank you.
Case 623, People versus Juan Colon. People versus Cologne, we have Ms. Culpet. Is it available? All right, you may proceed.
Good morning, Your Honors. Jessica Culpet on behalf of Mr. Cologne. I respectfully submit that the lower court erred in the failure to charge the jury of the lesser included reckless manslaughter. This panel is undoubtedly aware it must be considered in the light most favorable to the defendant. Given the facts and circumstances to how this death occurred, two vehicles driving at a high rate of speed, over 55 miles an hour on the expressway, and the specific testimony of the witnesses in this case, the reckless manslaughter charge should have been given. I would note not only the facts and circumstances specifically from Investigator Matina when we went through each of the circumstances of actually causing harm in this fact scenario in the 1 to 2 seconds that these shots were fired would be, but in the sudden and spontaneous manner in which they occurred, supported providing the charge to the jury of reckless manslaughter. Additionally, the court's consideration in denying the charge offered the wrong standard. The lower court indicated that they weren't going to provide the charge because it wasn't supposed that the gun was fired inadvertently or by accident. That's not what reckless manslaughter requires. Here, the facts and circumstances, I would point to investigator testimony supports that reckless manslaughter should have been provided in this scenario, and the failure to provide it requires reversal.
Right, thank you. Anything further?
Unless the court has specific questions, I'd rest on my papers for the arguments of the three other points I've made. And unless there's additional questions, I don't have any. Thank you.
Thank you.
Your Honor, first, my argument is that the facts did not support a charge of recklessness in any way. The defendant pulled up next to the victim's car, fired 7 shots into his driver's side door or just behind within a 2-foot radius and then sped away. There possibly would be an issue if the charge of manslaughter in the first degree was not charged, but there's no reasonable interpretation of that evidence that his conduct was involuntary or that he didn't intend to strike the vehicle with the weapon, strike the vehicle and cause serious physical injury.
All right, thank you very much, Mr. Bunch.
Thank you.
Next case is 626, People versus Nicholas Bryant. Mr. Keem is on video. 626 Bryant. Mr. Eagleson, good morning.
Judge, we have Bradley Keene. He's just taking a moment to come over.
All right, thank you. Mr. King, good morning. You may proceed.
Good morning. Sorry for the delay.
No problem.
Good morning, may it please the court. Brad Keene for Mr. Bryant. We assert here that the conviction should be reversed because the trial court lacked jurisdiction to sentence appellant. 390-30-6A says very clearly, in no event may the sentencing be adjourned for a period exceeding 1 year from the date the conviction is entered. We assert here that no exceptions apply.
Well, Counselor, what about People v. Drake, 61 New York, 2nd, 359? Doesn't that just say reasonable promptness and failure to may result in loss of jurisdiction? It's a Court of Appeals case.
Yes, I understand, Drake, but I would point the court to its own case in Carlson, where in Carlson there was a adjournment request by defense counsel, and defense counsel said that he was at fault for asking for the time. That's not this case, which is the trial court and the people really pushed them.
But your argument isn't that the sentencing took too long. Under 380-30, the CPL, your argument is that interim probation can only last for a year, and that the violation of that needed to be resolved within a year, and it wasn't. So the sentencing came a year later, therefore the court couldn't have imposed any sentence at all.
Correct. I mean, they had the opportunity to do a declaration of delinquency, which is the Dixon case. They didn't do that. In interim probation's mind, appellant had successfully completed.
But doesn't the Rollins case say that declaration of delinquency is not necessary?
I would say I do not have Rollins. What I'm arguing, though, is that the declaration of delinquency would have told it. It did not pull it here. Even if it's not necessary, the clear and unambiguous language of 390-36A says, in no event may it go over a year. And this is clearly over a year.
The question is whether the court lacks jurisdiction. I don't think the statute says that. Is there any case that you've seen where an appellate court or trial court, for that matter, has held that where there's interim probation and the sentencing doesn't occur within 1 year plea, the sentence has to be vacated? Is there any cases that you have?
No, absolutely not. But I think that there's a serious problem that would have existed if appellant would have done something in this 21-day period, which would have created a whole host of problems for interim probation. And that's why the rule should exist.
Right. Not an unreasonable argument you make. Anything further?
No, Your Honor.
All right, thank you.
Thank you.
Good morning, may it please the court. Chris Eagleton, in response for the people. I think that this court decided materially the same issue in Carlson in 2016. I think if we take a close look at the proceedings of 9/21/21, those were proceedings scheduled for sentencing. They were within the 1 year period. The judge at that time gave the defendant the option of going forward with the sentencing, admitting to the violation. I think, just to backtrack a little bit, the court was very interested in this issue of not having paid the restitution. At that point, I think the record is very clear. The defense attorney indicated not only that would she prefer not to go forward with sentencing, but would agree to the hearing, and then ask for a lengthy delay so that she could prepare for the hearing. I think that puts it well within the ambit of Carlson, and I think that case does control.
What if the facts here were different than Carlson? The defendant here said, no, I want a hearing now, or I want to be sentenced now. I'm entitled to be sentenced within 1 year of my plea, which I think would have been October 13th, 2021, and the court says, no, I need time to hear and schedule it beyond. What then?
I think the analysis changes. I think the result is the same. I think in that case, the analysis changes to whether it's a deferral or a delay, whether it's reasonable or unreasonable under those circumstances. I think that the court has a common law right to have full information prior to passing a sentence. And I think the court saying, I need more information, I think is an invocation of that right. And I think that makes it a deferral of a scheduled sentencing for a discrete period of time. And I think it takes it out of the ambit of this whole legal analysis for delay. I just don't think it would apply.
By the way, one final thing. Do we know if the court imposed 5 years of probation or 3?
My understanding is it was 3 with credit for time. I'm sorry. You know, I apologize, Judge, I don't
Court
recall.
said just probation, didn't say how long.
Yeah,
And then a clerk or somebody, now it's 5 on the records, but doesn't the court have to say how long probation is? Because it could be shorter than 5, right?
it can be shorter than 5, and he certainly didn't say that. He didn't declare the length of probation, although when he indicated probation, he's indicating, at the time of the sentence, he's indicating an understanding that was evinced prior, at the inception, when he pled, right? It's placed on the record what it would be. So I think there might be an understanding that it was 5 years at that point.
But it could be remitted to get some clarification from the judge in post-sentence.
Yes, Your Honor.
Thank you.
Thank you.
627, People versus Ronald K. Baker.
Good morning, Fabian Santacroce for Ronald K. Baker. Unless the court has any questions, I would orally submit at this time.
Thank you.
Thank you.
Mr. McCarthy?
Morning, Your Honors. Marty McCarthy for the people, and I'll do the same unless there's any questions.
Thank you, Mr. McCarthy. 628, matter of Jalen B. Mr. Degnan will appear virtually.
Okay, thank you, Your Honor.
Mr. Babylon, good morning.
Good morning. May it please the court, Thomas Babylon on behalf of Appellate Marion S. The first point I'd like to discuss today is the agency's absolute failure to prove its burden of proof when it failed to show that the child was present at any time when the conditions alleged in the room.
Right. You agree that the petitioner proved that the child was in the room at some point. You agree that the conditions as found when the hotel manager went back in and the police went in were deplorable and there would be neglect. You're saying they have to show that the kid was in the hotel room when those conditions were present, and that wasn't established here by a preponderance of the evidence.
That's correct, Your Honor. And this court has found specifically required when the agency alleges imminent risk that it's their requirement to prove that the child was present at the time that those conditions existed, and that's a matter of David W.
30
2020.
dirty diapers in the room when the police entered.
Yes, Judge.
30 dirty diapers. There was cocaine residue there, what appeared to be cocaine, suspected cocaine. There were knives. There was indications the child may have been locked into a closet with a scarf. With 30 diapers, you would suppose that maybe the child left after the 30th one, but it was clearly there for the first 29, right?
Well, Judge, the testimony was that my client was in the room for a period of 3 weeks. And even the agency's own proof shows that the child, at the time that the room was discovered, was in Ohio, because the agency contacted the paternal grandmother who admitted that the child had been with her for a period of 1 week at that time. So,
Wasn't there testimony the child was seen in the lobby of the hotel?
and yes, that, Your Honor, that goes to another point with regard to that evidence being improperly admitted under the best evidence rule, which is another point in my brief. However, that testimony by the hotel manager, she could not indicate a date when that video was. First of all, the testimony was unreliable. It wasn't an accurate representation of the original because she had to rely on other people to identify my client and the child, and she also had to. She didn't know the date that the video was taken. She said she testified reluctantly that she believed it was in the last week that she was there. However, the last week could have been 3 days. My client's defense had always been that the child's father had come into the room after she had left and the child had gone to Ohio and trashed the room.
Right, but your client, that's her theory. Your client didn't testify, and adverse inference can be drawn. The paternal grandmother, Brenda Burton, who lived in Ohio, you claim she admitted that the child was with her. I would say she alleged. Ms. Burton did not give her address, refused to give the address. The mother did not know or refused to give Ms. Burton's address in Ohio so that someone could check up on him. Burton didn't testify, the grandmother didn't testify. That there's no real competent evidence that the child was ever in Ohio.
Well, Your Honor, I would state that the judge in this particular case prevented my client totally from presenting a defense. I had prepared these witnesses the week prior, and I informed the court of that. The court was well aware of my client's defense and that these two witnesses would testify that the child was in Ohio at the time. They were to appear virtually, and they were given the team's invite. When the agency concluded their case, which was a period of hours, the court said that they were not in the waiting room and gave me 2 minutes to locate my witnesses.
I agree. I'm sympathetic to your position on that, but in your motion to vacate, I would have expected there to be an affidavit from your two witnesses to say, we were ready, willing, to able to testify, and this is what we would have testified to. You didn't have that. You didn't even have an affidavit from your mother, from the mother, I don't think, testifying, asserting what she would have testified to.
Well, and Your Honor, I will concede that was not there. And as the court may be aware from my brief, I was having 3 trials a week at that time. So it was very difficult.
I will say this, you vigorously represented your client. She did not get shortchanged in representation.
Well, thank you. But Your Honor, the point is, it's the agency's requirement to prove that the child was there. Not a single witness, not a single speck of evidence proved that the child was there at the time that these conditions were discovered. And there's nothing that could place the child at that time. It takes a moment, it takes a minute, less than a night for a hotel room to be trashed. Someone could rent a hotel room for one night and trash it. How long does it take to take a diaper pail and throw it across the room? Take a dirty diaper and smear it on the wall when someone's angry with their former significant other, or throw trash all about the room. It takes a matter of minutes, and for the department to fail to show that that child was present in the room is a deficiency. The court cannot find that the child was neglected if they can't show the child was present when those conditions existed.
We understand. Anything further?
Yes, Judge. If the court would entertain, I also would like to discuss the best evidence argument, which is crucial here because the court relied on the hotel manager's testimony regarding that the child was present as seen in the video, in her belief, in the last week of the video, to show that the child was present at the time these conditions existed. That testimony should have never been entered. It violated the best evidence rule. I objected on that basis. The department never showed that the evidence was unavailable. In fact, the witness testified the evidence is still available. I can send it to the agency right now. They had the evidence. They didn't produce it, probably because the time date was not consistent with their argument. So we never received a discovery, although we asked for it several times. We never received it. And she could not testify what the date was on that video. Primarily, the agency, under the best evidence rule, is required to show that the evidence is unavailable and it's not due to them. The witness testified she still had the video and could have provided it to the agency. So it certainly, if not, it certainly could be alleged that it was due to the agency that video was unavailable. And secondly, if that is shown by the agency, which it was not here, the department the court is required to find that the testimony is an accurate representation of the original, which here it clearly is not, because the witness could not even testify as to what the time-stamped date was on the video. So, and that is a crucial piece of evidence for this case, because if the time date was 3 days prior, or 4 days prior, or a week prior to when this room was discovered, it fully supports my client's defense that the child was in Ohio, and this occurred after the child had left, and after she had left the room, and her former significant other had destroyed it after becoming upset with her.
All right.
And then the other point I would like to discuss with regard to the case notes. I attempted several times to make specific hearsay objections to these particular case notes. The court prevented me at every single moment.
I agree. Can I just clarify one thing? The evidence to support your client's theory, your client didn't testify, didn't call any witnesses, they never showed up. This theory of being in Ohio, that came from the case note, did it not?
It came from the case for discussion.
That's this evidence that you say came in. Without it, there'd be no evidence of your Ohio theory.
Well, and Your Honor, but there also was other evidence that came in with the case notes that was clearly improper. Descriptions of photographs that were clearly hearsay, that were never admitted into evidence. Speculation that a scarf on a door handle was a lock used to lock a child. I would say to the court, it's perfectly normal for someone to take a scarf off and hang it on a door handle. And just like the evidence here is completely speculative that the child was in the room at that time, That was speculative, that was used as a lock. It was a scarf on a door handle. Your
Well, it
Honor.
looked like there was a makeshift bed in there, but we understand all your arguments. You raised a lot of good contentions, as you did below, and we will take a close look at them all.
Okay, thank you, Your Honor.
Mr. Marzocchi?
Yes, good morning, and may it please the court, Joseph Marzocchi on behalf of the petitioner respondent, the Onondaga County Department of Children and Family Services. I just wanted to respond to one of the arguments that the respondent appellant's counsel has made today and in the reply brief, just about the opportunity to present evidence. I think it's our position that the record clearly indicates that the family court gave the respondent appellant every opportunity to present evidence and then gave second opportunities afterwards, and that the respondent appellant, despite these offers, refused them, sometimes explicitly. There was correspondence between the court and respondent appellant about reopening the case so that these witnesses who had failed to appear for an unknown reason could come and testify. The respondent appellant explicitly rejected that.
It sounds pretty clear the mother did not want to testify. The court did clarify with the jail personnel, she was in jail at the time, and yes, she confirmed that, the court confirmed that the mother did not wish to testify, and the court drew an inference there. But it did seem like you were handicapped. Your client was handicapped because the manager of the Homewood Suites there was some emergency she had in her family, and she's testifying, and she didn't have any dates, notes, anything in front of her, so she didn't really know much about when the child was there or anything. That was a real handicap that makes it a lot harder, made it a lot harder for you to prove the case, did it not?
I think the manager did indicate a general time period when the respondent appellant was residing there, and if I can remember correctly, it was May. I may be misremembering that, and I apologize. But we also had the case record that was introduced. There was also conversations between caseworkers and the respondent appellant about her stay at the hotel. So I think all of that corroborated the first witness's testimony. And I do understand the court's point, though, that she did seem like...
She was testifying, looked like on the way to the hospital or something.
Yes.
In a car.
It was unfortunate. We had planned, but...
Well, is there any direct evidence that the child was in the room under those conditions as found by the manager and the police officer?
That is to say, did anyone see the child in the hotel
With those conditions
in those
present?
room?
No,
just
right.
in the lobby. Again, it was...
Well, in the lobby when?
In the lobby around the time that she was staying at the hotel.
Well, yeah, Mr. Babylon is suggesting you need some more evidence than that, more concrete. He agrees the room was deplorable and dangerous, and if the child was in there, then there'd be neglect. But you got to tie the kid to the room at the relevant times, and there's no direct evidence. You're just saying it's circumstantial, it's close enough.
Well, I think there's quite a bit of circumstantial evidence, and the court pointed this out. The children's bottles, the baby bottles, the diapers, the children's toys, the children's clothes.
Show that the baby was in the room at some point.
That's correct, during the stay. And I don't think there would have been any other way for, the manager certainly wasn't going to let herself in unless there was non-payment. So, and unless the court has any other questions, we will rest in our brief. Thank you.
Case 629. Oh, I'm sorry, yes, we do have somebody on video there, the AFC. My apologies to you, sir. You switched your argument the last minute to virtual. Threw me off
Yes,
there.
I do apologize, Judge, just with the court protocol, so thank you for allowing me to do so. Your Honor, this case certainly was circumstantial, and had the respondent appellate been here to testify, she certainly could have denied on the record and provided her side of the story where her son was. And I think that's the critical flaw in this case, is that she refused to go to her incarcerated jail cell at that time. And that would have made all the difference in the world on this case. The county, in my opinion, certainly met their standard of proof that the child was there. What child was there then? Had it not been my client, and obviously there was a child in those deplorable conditions, and the county certainly would have filed against that child. And then just in terms of the argument that this was a default, Mom had a full opportunity to participate. She participated in the trial through her attorney, and it was done on the merits. I also like to point out that the disposition was done on consent, Your Honor. So the only issue I believe that's before the court today is the underlying fact-finding order on the Article 10, the neglect petition, that the dispositional order was not preserved because that was done on consent.
We understand. Thank you.
Thank you, Your Honors.
629, Ruby Belton, MD versus Borg and Ide Imaging, PC. Good afternoon.
Morning, Your Honors. Philip Stack, may it please the court, Philip Stack for the appellant. This case involves a complaint of discrimination that was dismissed in federal court and refiled in state court pursuant to CPLR 205 subdivision A.
It was really dismissed pursuant to 3211, correct?
Well, the case was dismissed in federal court, refiled in state court under CPLR 205A, and then dismissed under 3211. But the basis for dismissal under 3211 was the dismissal in federal court, not a reevaluation.
And the issue there, if I understand it correctly in terms of the way the briefs are teed up, is primarily whether or not that decision in federal court was on the merits, so to speak.
That is correct, because that's what CPLR 205A requires, and while we may disagree with the legislature as whether that's the correct way to go, that is what the legislature has provided. So,
And if I have it right, Counselor, just, it looks to me I'm looking at two competing cases, because each side cites, obviously, different cases. I think the other side cites McLaren from the Court of Appeals about an adjudication on the merits in federal court, when the court in federal court doesn't say so, contrary to New York courts, that it's on the merits, unless it otherwise specify, according to the case that you cite, which begins with Lex, L-E-X something or other, where it basically says, well, the court makes clear, the federal court makes clear, that it's just based on the adequacy of the pleadings, that it's not on the merits. And so just so you know, the panel is familiar with the facts, we've looked at the briefs. Am I close on the issue for the benefit of my fellow panelists here? Am I close on the issue?
yes, Your Honor is close on the issue, and I certainly appreciate the court's diligent attention to these arguments. I think what's critical here is that the federal court did not say it was on the merits. The federal court itself invited the plaintiff to submit, to make the motion to amend the complaint, submit a new complaint, would rule on that complaint. And in the cases that we cited in our brief, many times the federal court does that and then rules that the amendment would be futile, there's no point to it, and you can't go in state court.
Sorry to interrupt you again, Counselor, but the way I read the federal court's decision, it kind of looked like you didn't even actually ask to file an amended complaint. You just kind of threw it in your papers.
Well, I wasn't counsel.
I'm not casting aspersions on anyone, but I'm just saying that as I read the federal court decision, that seems to be the whole focus now on amendment was kind of an after-the-fact thing for whatever reason.
Well,
but what we really have to look at is whether it's on the merits.
Right, and the federal court certainly invited the opportunity for an amended complaint to be submitted. That
Where do you find that in the record?
That was in the federal court's decision, and then there was a motion made for sanctions and attorney's fees on prior counsel, and in that decision, which we also refer to in the brief, the federal court repeats the same things and in fact notes that the plaintiff was pursuing an amended complaint in state court. Now, as an attorney, and we've all been there, we are entitled to look at CPLR 205A. I could have gone back to the federal court and made the motion to file the amended complaint in the federal court because there was nothing barring me from doing so. The court didn't
accept the judgment.
No, the judge had invited that. The judge said you could submit it. So in any event, what I decided to do was, because CPLR 205A allows that to be done, is to submit the amended complaint to the state court because the breach of contract claim had to go to state court, and if we were successful in the federal court, why would we want to litigate two cases in two different forms?
Plus, it didn't look too promising with Judge Larimer at the helm over there.
I have no idea, I am from the Northern District of New York.
Well, based on his decision that he wrote.
I don't know. I can't say. There are many other options. We could have moved it to amend the complaint, then gone to the Second Circuit. I think one could.
It's not relevant really to, but
Yeah.
would you agree that the complaint in federal court is substantially similar in many respects to the complaint in state court?
There are certainly some facts that are the same, but one of the problems that you get into in a discrimination case is the defense always likes to say, you don't have direct proof that my client had discriminatory animus, but every case, if discrimination is circumstantial.
You're not going to get it.
What's that?
Unless they admit it, you're not going to get it.
Correct, which nobody does. So the point is, you may have 2 or 3 facts that you allege in your original complaint, and then you add another 10 facts, and it makes the circumstantial picture of discrimination much clearer. So the complaints are not the same. I think for one thing is certain in this case. Had this complaint been brought in the state court in the first instance under the state standard of notice pleading, it could not be subject to dismissal. It might later on go down the road and be subject to summary judgment, but not dismissal under notice pleading. That's why it's so important that the federal court decision be on the merits. And again, what I would reemphasize is certainly in reading the judge's decision, he did say he didn't have an answer to Judge Curran's question. The judge did say that the procedure for going to amend the complaint in federal court was not followed because no proposed amended complaint was submitted. There was nothing for the judge to rule on. So what we felt was the best course of action, given the fact that we had to pursue the breach of contract in state court, was to just do the repleading in state court. If we had not done it that way and waited, by the time the federal court got around to deciding the motion to amend, we might not have been able, under CPLR 205A, to bring a case in state court.
205A pertains to the statute of limitations, basically.
That is correct. So this is an opportunity, as the cases have said, to revive a pleading that was dismissed, not on the merits. So unless the court has further questions, I don't want to go through the particular instances in the complaint, which I say are different than the federal complaint. I will note one final area of disagreement between the parties, which is in our causes of action, in our race discrimination claim and in retaliation. This is the record, pages 23 and 24, paragraphs 58, 65, and 66 of the complaint. What we did was, first we pleaded all the facts that had happened over these many years in this case, and then we summarized them. I think it's unfair of respondents to characterize that summary as some conclusory assertion when every single thing that we allege in those two places was specifically pleaded earlier in the document. Thank you very much for your time and courtesy.
Thank you, counsel.
Good morning. May it please the court. I am Stacy Trian from Adams LeClaire for the respondents, Borgonite Imaging PC and Radnet Inc. Contrary to the appellant's statements, the federal decision here was decided on the merits. The federal decision did not grant leave to replead.
You would say we should follow McLaren from the Court of Appeals?
Correct, Your Honor.
And that there was nothing in the decision of the federal court to suggest that it was purely on the sufficiency of the allegations in the pleading, and therefore the judgment once entered in federal court is res judicata with respect to any similar or substantially the same, whatever the language is, of the causes of action here.
That is correct, Your Honor. To correct one other thing, the federal court's decision explains that the plaintiff in that case did submit a proposed amended complaint, and that decision states that the plaintiff was not permitted to so amend the complaint because the proposed amended complaint failed to correct any of the pleading deficiencies. There are no cases that are cited by the appellant which would state that a case that was dismissed under Federal Rule of Civil Procedure 12 for failure to state a claim was not a decision on the merits for purposes
The
of res
Hernandez
judicata.
case, which is a lower court case, but it sets forth the law pretty well with respect to the competing cases. We've read that as well.
That's correct. And in the Hernandez case, there were the additional facts where the plaintiff had pled additional facts that postdated the federal action and also pled additional causes of action under the New York City human rights law that were different than the ones pled in federal court. That is not the case here because the same allegations under the same New York statute were filed in state court as were dismissed subsequently. I would also point out that the Supreme Court here also did find that alternatively in this case the complaint should be dismissed for failure to state a cause of action under the New York State human rights law, and that even under New York jurisprudence to state a claim for discrimination and retaliation, there's a minimum level of pleading that is required that was not met here.
Thank you. Anything further?
No. Thank you.
Next case for argument this morning is 630 Vasquez versus Gilbane Building Company. 630.
Good morning, Your Honors. May it please the Court, Justin Hendricks on behalf of the appellants. This accident is not one of those exceptionally dangerous conditions posed by elevation differentials at work sites that Section 241 prescribes safety precautions for workers laboring under the unique gravity-related hazards, but rather resulted in the type of peril a construction worker usually encounters on a job site.
Let me ask you this. If we substitute a ladder, the ladder's leaning against the wall and it was either hit by the wheelbarrow or just fell over on the plaintiff. If it weren't a ladder and there were a heavy metal beam leaned up against the wall and somehow, for whatever reason, it collapses and it hits the plaintiff, there's liability there as under the falling object theory, under 240 sub 1?
I would say that if the beam in question were, large enough that it would fall under the body of case law that's been prescribed, where the case that Respondents' Counsel submitted makes reference to a load position on the same level as an injured worker follows due to its weight is capable of generating significant force. Yes, but this is not a heavy I-beam or some other piece of construction equipment or even debris. I mean,
it's a 32-foot heavy Stanley ladder.
It's a ladder that...
So 32-foot heavy Stanley. Have you ever worked with a 32-foot ladder?
Well,
extension ladder?
Well, yes, Your Honor, and I would say that, a 70-pound ladder is very different than a multi-hundred, if not ton, I-beam.
So do we look at the weight of the object that falls to determine whether there's liability?
I think that due to its weight, absolutely, Your Honor. I think that's, without question, a vital component to this analysis.
Counsel, you cite to a case called Miserati.
Yes.
That talks about, I think it's the usual conditions of a construction site, something like that.
Yes, Your Honor.
Does that apply here?
I think that it has to apply here because I think we would be hard pressed to find many construction workers who would see a ladder not in use, in its smallest collapsed form, leaning against a wall, and say that that is somehow atypical for a work site.
On contrary to perhaps the Justice Prezzidi's question about the beam that might have been put there, for all we know, as part of the construction work, it's being moved, whatever it is. Here, a ladder is not being, there's no question it wasn't being used as part of the work on that particular day, as I understand it. So that would be more akin to something that's typical for a construction site, as opposed to a beam that, for all we know, we don't know the source for why it's there and what it's being used for. The ladder, we know it's just sitting there waiting to be used. So is that another distinction?
Absolutely, Your Honor, you have summed up our position very well.
I didn't mean to, by the way. I'm just trying to understand the two sides of the argument.
Yes, but that, I would not pretend to be able to articulate it better than you just did. That's our position.
If somebody were working on the ladder, of course, it would have to be secured. If the worker fell, then it's a falling worker situation.
Yes,
Right,
I could not argue that.
But there was nobody on the ladder. So your
Correct.
position is you have to tie it off if somebody's on it, you have to secure it, somebody holding it, what have you. But if nobody's working on it, it can be in the exact same position and there's no securing needed, is your view?
Yes, because it's not being used.
But how does the outdoor v. City of New York, doesn't that go against your position? Familiar with that case?
I'm sorry, Your Honor, I'm not remembering that case off the top of my head. Was that?
It's OUTAR v. City of New York, 286, 82nd, 671, Second Department. And it was affirmed at the Court of Appeals, 5 New York 3rd, 731.
That's the Dali case, you know, the unsecured Dali subway.
Thank you, Your Honor. I think that the important distinction here, again, would be that, you know, for starters, I believe the Dali in question would have had wheels. So there certainly would have been questions as to what securing was used relative to those wheels, whereas here we have a ladder that is supposed to be stationary. Of course, there are various requirements necessary for securing it beyond whatever cleated feet it may possess.
How do you answer the plaintiff's position? As I understand their motion papers below and on appeal, they're arguing that the proper means to secure this ladder was to put it on the ground.
I guess my immediate response would be, to be crass, but says who? I mean, like where's the authority that states that? But even beyond that point, you know, I would say that a ladder is such a expected piece of equipment at a construction site, and it needs to be placed somewhere. And where it was placed in this construction site was not atypical, and it was not unexpected.
At most, you say it was just negligent to do that, just a negligent act, at most, but that.
I mean, I don't think it was even negligent to put it there the way that it was there, no. But even if that were the case, negligence certainly wouldn't be sufficient to raise it to violating 240 sub 1.
We understand.
There's a case I don't think anyone cited called Buckley out of the First Department. And there was a 4-1 or 3-2 decision going back to 07 that seemed to define, so in a way it might be too old, but seemed to define that as the risk on a construction site, that is for something to fall over, for a falling object, it has to be, I think the language is reasonably foreseeable or foreseeable. Couldn't the argument be made here, as I understand the facts, that when you're demolishing things in a violent way and they're falling from the roof down to the ground, that anything in the area should have been secured, including even this unused ladder? Isn't that a decent argument?
I suppose that is an argument that could be made in the generalist of senses, sure, but I don't think it's applicable here to the extent that I don't think that was proved here as a matter of law that would mean that section 240 sub 1 applied and that the defense was no longer able to present to the jury any liability defense whatsoever, and we move purely to a damages trial.
Now, to make sure I've got this right, I don't see anything in your brief. Do you agree or not is ultimately the question. But is there anything in your brief where you say that the plaintiff failed to show that there was an inadequate or missing safety device vis-a-vis this ladder? I don't see
That's
it, but
specific. No, I did not make that specific statement in my brief, Your Honor. No.
Last question for me at least. This Milano case, the trial level case that the plaintiff relies on, it's a ladder leaning against the wall case, seems to generally support their position. What do you say about that case?
I'm sorry, Your Honor.
I'm sorry, go ahead.
Yeah. For Milano, I honestly, I do not remember the specific facts of Milano off the top of my head, Your Honor. I apologize. I'd have to.
Actually, I think that was actually a case in your favor, perhaps. But
Oh, okay. I don't.
It's a question more for opposing counsel. All right, we understand your argument. Thank you very much.
May I, Justice Presiding, ask, I forgot to poke my head out a second ago. Are you planning to address or just rely on your brief, and I'm fine with either personally, with respect to the amount of the future damages award?
Only to state that I disagree with the assertion that it was not preserved from the notice of this appeal.
It's a weight of the evidence situation, right, for the amount of the damages. So weight you can appeal directly. We've got a recent case that says exactly that.
And on top of that, Your Honor, also there was a timely post-trial motion made to the trial court when we were appealing that order. So, I mean, it's certainly preserved and before the Honor. But beyond that, yes, my only final point would to say that if the court should decide to rule in our favor that there was at a minimum a question of fact regarding 240 sub 1, I would ask this court to please address 241 sub 6 and strike out, to deny 241 sub 6, specifically the plaintiff's opposition papers on this appeal. Only even make reference to 3.3C and 3.3K. I don't think either are relevant, and thank you.
Thank you.
Good morning. May it please the court. Alan Vos, Maxwell Murphy for the plaintiff, Nydia Vasquez. Heavy-duty demolition going on. Beams, everything being thrown down, just as Justice Kern points out. You've got people working in this area. Nydia has to protect herself by getting in the area where all these ladders and other things are because of all the material that's coming down. She does so waiting to go back into the area where this material is being thrown down to be able to pick it up when it's safe to do so. She's then exposed to this risk. It's not just a ladder standing there, it's a ladder standing there in these circumstances. And I would submit it's absolutely indistinguishable from the case, the Gregorian case that we sent in, where there's a fire pump standing on its end, and it falls over and strikes the plaintiff. Summary judgment granted. And the court noted the fact that the fire pump was unrelated to the plaintiff's work was irrelevant. And I should submit that's the same here. So,
Mr. Voss, here's what's somewhat troubling me. I'm not sure how far this goes, but we've got a case called Floyd versus New York State Thruway Authority that quotes the Court of Appeals with respect to the two elements of a falling object case. You'll remember this. Actually, I don't know if anybody cited it, but and then we have a recent case called Vicky versus City of Niagara Falls that quotes to Floyd as well. It says that generally a plaintiff seeking to recover under 240 sub 1 for injuries sustained in a falling object case, which this is, right, must establish both, one, that the object was being hoisted or secured, or that it required securing for the purposes of the undertaking. And I think you're relying on the latter in that one, right?
we are.
Okay, so hold that thought, because
Okay.
I'm not sure there's much dispute there. I'm not sure. And two, that the object fell because of the absence or inadequacy of a safety device to guard against a risk involving the force of gravity, the application of the force of gravity. It looks to me, and I just want to make sure I'm reading the briefs correctly, that the parties are only debating element 1 as to whether or not it should have been secured. I don't see any argument from the defendant, do you, that says that you failed to identify an inadequate or missing safety device? Am I close?
I believe that argument has not been made by the
And if it had been made, you might have been able to turn around and say, well, geez, you should have just tied it to the wall or something like that.
Precisely. Precisely. And I think, other than semantically, I think tying it to the wall and laying it down are indistinguishable.
Well, the laying it down the wall bothers me for two reasons, potentially. This is what I'm a little worried about with this case, is to say that every ladder on a job site like this has to be put down on the ground. That is not involving an inadequate or missing safety device. So if you just argued that it's enough to put it on the ground, you may not have the second element. But here in this case, if the second element's not being debated, we may not have that issue in this case. That's what I'm struggling with. Am I making any sense? And if not, go ahead and tell me.
No, absolutely, Your Honor. And I think what we're talking about is workplace safety statutes. We have a hazard posed by a potential falling object. As you said, eminently foreseeable that this thing can fall over. I think we've got to look at worker safety. That's the legislature's intent, and that's what we're looking to accomplish.
But are you seeking to establish in this case a rule that every ladder on the site, in a construction site, has to be secured to the wall or the subject of some safety device, or alternatively, the statute requires they always have to be put down on the ground? That's a big rule that makes some people uncomfortable, perhaps.
I don't think the rule has to be that specific, Your Honor. I think the cases that we have that talk about falling objects that need to be secured, and again, I say laying it down secures it. Any object that needs to be secured needs to be secured. Not every ladder, every this, every that.
Well, under the circumstances of this case, which is what you've already said, that is, you've got demolition, you've got falling debris, the person has to basically hide in the doorway to avoid it, and there's vibrations that apparently were enough to knock over a 32-foot high ladder. So that's why you say it requires securing. How it's secured is kind of beside the point, since the defendant hasn't argued it.
Correct as to the second, and as to the first, I think it's those factors that set this apart. It makes it not a general rule that every ladder on every construction site needs to be laid down or tied off. When you've got these circumstances that endanger people because of the potential, it's like the cases we have where the wind blows things over.
Just a minute, Counselor. It's not the circumstances, it's the gravity-related injury. Are you asking us to draw some distinction here?
No, I don't think so. If it sounded that way, I misspoke. I'm saying the circumstances.
This isn't any ordinary object. This is a tool, a common workplace tool, or piece of equipment. And it doesn't seem to have a natural tie-off, does it, on the side of a building? I mean, the only other option is to lay it down.
Well, there are plenty of falling worker cases that say you have to tie them off, so there's no reason you couldn't.
A ladder laying against a wall. There's no natural way to tie that down to the wall, is there?
Well, there's
You
no
have to
proof
lay
that-
it down.
There's no proof here that it couldn't be tied off. Your Honor, I don't know whether it could have been or not. There's
Well,
no
I mean,
proof it could
common sense. I mean, the only other alternative is every ladder has to be laid down if it's not in use.
Again, respectfully, I disagree. I think in circumstances presented, that we have presented here, circumstances such as these.
If you got vibrations going on.
Demolition and those sorts of things happen.
Only on demolition sites does the ladder have to be tied off or laid down.
No, I think that, as I said, the other cases that involve wind. If you've got windy.
How much wind?
Enough to knock it over.
Right, anytime a ladder falls, in your position, anytime a ladder falls, if it's not tied down or laid down, it's a 240 case.
No. Only if there are external forces at work that
Well,
would
the
call
only
it.
external force we really look at is gravity. 240 is a gravity, that's the external force we're concerned about. Not wind, not vibration, gravity.
But your argument is that the wind and the vibrations can cause gravity to come into effect. So if somebody's painting outside, they have tall ladders and so forth. If it's a calm day, unsecuring the ladders, perhaps not a 240 problem if the ladder tips over. If, however, high winds and gusts and so forth, they leave it in, ladder falls down, then you're in a better position. That seems to be what you're arguing.
Yes, and I thank you for phrasing it better than I did. It's the external forces that act upon the object that bring gravity into play, that make it a hazard. And that's, I think, the distinction that we're trying to make.
Well, it's a big distinction because we've got a lot of ladders out there, and if you've got, let's say, an exterior painting site, and we have a worker up on a ladder and they need to go back to their truck to get another paintbrush, your position is, depending on the wind, they might have to lay the ladder down or they could leave the ladder up.
Correct.
Sounds like negligence, but in any event, do you wish to be heard on damages?
Your Honor, only two simple things. We submit with regard to the lost wages, it's not preserved. We've fully briefed that. With regard to any offset on the merits, any offset for lost wages. The plaintiff's treating physician testified she's disabled from all gainful employment. So therefore, any other further disability couldn't have affected the amount of her loss.
Thank you. Case 31 is Flanders versus Nilsson.
Good morning, Your Honors. May it please the Court, I'm David Sealing on behalf of the appellant. This is a probate proceeding in which a summary judgment was filed only 23 days after the filing of objections. In our brief, we argue that the Court was unable to entertain this proceeding as a result of a jurisdictional issue, which is set forth in our papers. I'll note that upon review of the responsive brief, there are some issues which are not in dispute factually. It is not in dispute that only one witness was produced in support of the instrument offered for probate. It is not in dispute that no citation under SCPA 1411 was ever sought or ever obtained or served.
But your client appeared, correct, and filed objections?
That is correct, Your Honor.
Can I just make sure I understand what's at stake here? You're challenging the 2012 will.
That is correct.
There was a previous one done shortly before that, 2011, that is unchallenged.
That is correct.
And the two wills don't alter who gets what. The only difference is your client is not executor anymore.
That is correct, Your Honor.
So if you prevail in this appeal and then ultimately prevail in the proceeding, he gets the same amount as he was. The only difference is he's in charge. Is that fair to say?
There are certain bequests of personal property which appear to have been removed from the estate. He would have the authority and a stronger position in handling those issues, but largely, yes, and this was not raised below.
Right, so
Is he an executor or co-executor under the old will, under the 2011 will?
My understanding is that he would be the executor.
The sole executor?
That's correct. The new will was had a co-executor provision, and that co-executor declined to serve.
So not as much at stake here as we see in most probate proceedings.
That is correct.
The money's going to the same people regardless of what happens. It's just who has the task of being executor, maybe get a fee for that.
That is correct, barring the outcome of discovery proceedings, which he would have a stronger position to entertain or to bring. He feels that he is aware of some things which he has not had an opportunity to investigate. Whether he proceeds after the outcome of this proceeding under 2105, which is the discovery proceeding which can be brought by an outsider looking in, or 2103, which is a proceeding brought by a fiduciary, makes a difference to him, and he has directed this appeal. I'll just note, finally, the other facts which are not disputed is that there is outstanding discovery and that no bill of particulars to which the petitioner would have been entitled as of right were ever sought. And in fact, had they been sought, he would have had time to respond in advance of the filing of summary judgment motion.
What showing does he make in his papers that this discovery that was not completed would lead to some sort of, admissible, evidence that would help him in this case?
There is no showing that the evidence he anticipates getting. I will note his primary objection is the undue influence of the petitioner, and until such time as he files objections in a petition for probate, against a petition for probate, he's not in a position to depose her.
Thank you, counsel. Mr. Stan.
Good morning, Your Honors. May it please the Court, Bradley Stam for the respondent. I will simply say that the petition for probate was in March of 2021. The ultimate decision from the court came over a year later. There was a lot of different things that happened during 2021. There was absolutely nothing brought up, raised, which makes me wonder why Mr. Sealing's saying that his client didn't have a chance. There was months and months and months and months and months of nothing. And the court directed the parties, as Your Honors are aware, through the record, actually following up from an email that Mr. Sealing sent to the court, page 98 of the record, page 99 was the scheduling order, where the court laid out what was happening. In fact, in that email from Mr. Sealing, he says, it would appear that the motion needs to be heard before anything else can happen. So I have to be honest, we were confused by this sudden, well, the court didn't follow the right rules. So that's pretty much is our position, Your Honors. If anybody has any questions, I'd be happy to answer them.
Hearing none, thank you.
Thank you so much.
632, matter of probate of James Scher. Mr. Calisano, who's the appellate's lawyer, is appearing virtually, and you have to unmute yourself, counsel. There you go. You may proceed.
Good morning. Thank you, Your Honor. May it please the court. I am Jennifer Calisano. I represent the objectant in the lower surrogate court proceeding, now the appellee, Antal Zerai. I would like to just highlight a few of the reasons why I asked for argument today. The principal basis for the decision in the surrogate court was that Judge weighed two of the witnesses, both of whom are, one is the direct beneficiary, the other is beneficiary through his marriage to the beneficiary, his spouse. The surrogate court weighed the credibility of these two witnesses who gave deposition testimony, and the proceeding was at the point on summary judgment. And if you look at the court's decision, the lower court's decision, what the circuit court is apparently seeming to say is that these interested witnesses can testify in a deposition and have their interested testimony weighed in their favor on summary judgment, which is fairly inconsistent with a substantial body of precedent that goes before this court's decision. What the court is also seeming to say is there needs to be direct evidence of undue influence. And we know from cases like In re Walther that the standard in will contests of this nature is that undue influence is often, in fact, almost always based on circumstantial evidence. And in this case, we have a great deal of circumstantial evidence that the decedent, James Scher, was dependent on entirely these two confidential agents of his.
Well, Counselor, if I could interrupt you and get to the other issue here, your point with undue influence is that the attorney who prepared the will and oversaw the will was directly related to the principal beneficiary.
That's
and
correct.
As a matter of law, that can't be resolved on summary judgment.
That is correct. That is correct. The only testimony, there were three witnesses who gave Rule 1404 testimony. The two witnesses to the will, they both testified that the beneficiary of the will was present during the will execution, and that the attorney and the beneficiary and the decedent spoke Hungarian during a substantial portion of the will signing, so that they could not testify at the 1404 hearing as to what exactly was said to the decedent about the will. The attorney drafter also testified at the Rule 1404 hearing, and she gave a wild explanation for how it came about that this will was even prepared. She testified that the only source of information about the desire to change the will came from the beneficiary's husband, who was also the decedent's power of attorney and healthcare proxy. The beneficiary was also a confidential agent, and Mr. John Puskis, who was the power of attorney and healthcare agent, testified that the attorney, his daughter-in-law, should not have drafted the will. The circuit court didn't, on summary judgment, the circuit court didn't consider any of these other pieces of the testimony when she weighed the credibility of John and Agnes Puskis, who didn't testify before the court. They were not at the 1404. They did not give 1404 testimony. They gave deposition testimony.
Right. 1404 is narrowly limited to the execution ceremony and the witness observations. But and did the court address your argument in its decision relating to the role of the attorney?
Well, the court didn't, except in passing, say that this attorney was related.
Right.
The court didn't consider in totality this body of circumstantial facts, all of which, according to prior precedent, would have demonstrated a fairly strong circumstantial case of undue influence. So what this decision seems to represent is that objections to probating a will of this nature have to now have direct evidence, which of course we understand is extremely difficult because we have a decedent who can't testify on his own behalf. And in this instance, the only testimony that the court relied on were all interested parties to the will, either beneficiaries or, in the case of the attorney drafter, related to the beneficiary.
So you want us to remit for a trial on undue influence. Do you think the trial should also encompass capacity? Doesn't seem to be a whole lot of evidence that the gentleman was unable to make up his own mind there at the time.
Well, it's my position that there was sufficient evidence here that the attorney drafter could not offer an explanation for this will. We had asked for summary judgment, but the logical course of action, I suppose, would be for the court to remand for a trial. The issue of incapacity, again, we have individuals here who, all of whom are testifying, they're all related to each other, and they're all interested in the outcome of this will.
And they all had their hands in his pocket.
And they helped themselves.
What's most disturbing here is the male friend sold the house and got a 50% commission. His kid gets $3,000 for moving some property from one place to another, which couldn't have taken that long. His wife gets $10,000 just for whatever and gets paid weekly to take care of him when he's in a nursing home, presumably getting those services anyways. All sorts of red flags here is what you're saying.
Yes, and I would also like to highlight a particular portion of the circuit court's order wherein she writes about the testimony of these witnesses saying they were family friends. They were family friends. And she also testifies about the confidential relationship not having been exercised. And that somehow making a difference in the applicable standard. And the point that I would like to emphasize here is that there was ample evidence that the Puskises helped themselves liberally through their confidential agency with the decedent. And it is simply inconsistent with the evidence for the lower court to have found that these people were family friends, that they weren't related, that they were friendly. There was plenty of inconsistent evidence that they offered themselves to show they weren't friendly prior to him becoming hospitalized, and that they helped themselves to his assets in ways that friends or family members never would.
We understand. Thank you very much.
Thank you, yeah. Thank you.
Mr. Seeland.
Thank you, Your Honor. Davidson on behalf of the respondent. I'll note at the outset, this was a fully litigated probate proceeding in which both the objectant and the proponent moved for summary judgment. The argument now that the very testimony submitted in support of the objectants and now appellant's motion for summary judgment is insufficient to resolve the issue, goes against the position taken below. And
Well, Counsel, let me cut to the chase here. Isn't the real problem you have here is that the attorney who drafted the will wasn't independent? If you had an independent attorney who says, I did what the testator wanted me to do, we'd have a different case.
the relationship between the attorney, who is now the respondent, was that she is married to the beneficiary's spouse's child from a prior marriage, is married to the respondent, the attorney drafted the will.
Wait, the attorney is called by John to come up by train from New York City.
Correct.
To draft this will. She doesn't know the testator, never met him for the first will. She comes up by train, and her instructions for drafting the will come from John.
That's not borne out by the 1404 testimony or the testimony.
It was her testimony. It came from John, and then she has a meeting. But the short of it is, isn't this the problem? Because you don't address in your brief the Elmore case or the line of cases.
The recent line of case out of the second department, if I'm not mistaken, this is a species of undue influence, which would even a holding saying, hey, we need the language is we need an explanation.
Right. We got a case where an attorney wrote a family member into the will.
Without, by the way, even consulting with the guy first. My understanding is that the lawyer received a call from John several days before the decedent and said, hey, he changed his mind and wants to make a new role, making Agnes the sole beneficiary. So the lawyer, Ola, drafts the will in New York, hops on a train and goes to Buffalo, doesn't even talk to the client, her client. And then she just goes to the nursing home and everything's already set up. That doesn't seem untoward to you?
Nope. And there's one other piece to this, if I may add. She stayed at John and Agnes's house during this time. John and Agnes drove her to the nursing home.
So the question that would be presented is whether an explanation for those circumstances is required. Explanation was provided. The court below held, and this is similar to the allegations of a confidential relationship. What would the product of a finding of a confidential relationship be? What would the product be of a determination that an explanation is required due to the relationship of the attorney draftsman to a beneficiary? It would be a clear and convincing evidence standard, much like any undue influence claim. The court below, in assessing all the evidence, found that the will was not the product of undue influence by clear and convincing evidence. Our position, and the one we've taken in our brief, it's more articulated on the issue of a confidential relationship. The allegation of that is that the question is obviated by a finding on clear and convincing evidence that the will was not the product of undue influence. The concerns that are raised when you have a beneficiary related, albeit it's close. It raises concerns under the cases which you referred to and which are very fresh. They are a species of undue influence, which would require exactly the finding that was made below.
Thank you.
Thank you, Your Honor.
Thank you.
634, Brian Aldrich versus LNG Enterprises Incorporated. Good afternoon.
Good morning, Your Honors. If it may be pleased the court, Joseph Calmary for the appellant Brian Aldridge. Your Honor, before the trial court was in the main issue as part of this appeal is whether or not the court erred in granting a summary judgment when we believe the plaintiffs established genuine issue of material facts that would warrant a hearing on the issue, whether there was an oral modification, and based upon that, when the statute of limitation both would accrue and since expired.
Counsel, you agree this was a demand note? Did I read your brief correctly in that regard?
A demand for principal in the interest of due on annual installments.
But it's a demand note for purposes of the accrual date, is how I read your brief, that you don't dispute that.
Correct.
Okay. And the accrual date can be one of three dates. That is the date of the note, the date of the last payment, or as you argue, the date of this purported oral modification. Do I have the three choices right, or is there something else?
No, that's accurate. We also concur that based on the way the note was read, and that is an open-ended promissory note, and that the way the annual installment payments were made, that the court erred in making the determination as to when the statute of limitations terminated, based on not the last payment, but the first failure to make the annual installment payment. So to go in more depth, the court noted that the statute of limitations would have expired in 2015, 16 years from the last date of payment.
That is generally the law, correct?
Correcting, but because the annual specifically provided in the note that there's annual interest payments due on the note, that until that annual payment was not made, that in of itself would have been.
Did you make that argument anywhere?
We did, Your Honor. It's in our brief. Then, and that's why we made, we highlighted that.
I thought your argument was it accrued in September of 13. I think.
Oh, no, my apologies, Your Honor. That is our primary argument. In line to your questions, that was our assuming arguendo
You
argument.
used that at a fourth date.
Yes, Your Honor. Our primary argument, Your Honor, was that there was an oral modification. That oral modification was made in 2013, made prior to that, that the note would then be deferred until the community bank loan had matured in 2013, warranting a 6-year statute of limitation from that date.
Didn't the note require no oral modification?
The note did require that, Your Honor, but as cited by the trial court, that the parties can overcome the no oral modification clause based on course of conduct and performance. We believe that is specifically the issue that warrants a trial on the facts. We rely on the fact that we have the plaintiff's absolute statement about the time, location, and where that oral modification was made. We have the fact that there was a shareholder meeting in 2015 where everyone acknowledged that the payment was.
But you're not relying on an acknowledgement of a toll or acknowledgement of an extension. You specifically disavow any reliance on that section of the GOL, whatever it is.
Correct, Your Honor. We believe that is completely inapplicable here because we're not arguing that there was an extension to toll or extend the statute of limitations. We're arguing the fact that it didn't even accrue until 2013. Other than that, Your Honor, I'll rest. Of course, any questions, if not, I'll rest on my papers.
Thank you.
Thank you, Your Honor.
Counsel, good morning.
Good morning, David Civilette for the respondent, and I acknowledge that I might be the last person between you and lunch.
Well, we have one case on video, but almost.
Well, we have a note, and the note last payment was made in 2009. The action was brought. There was a complaint that alleged only the note.
There was no mention of the oral modification in the complaint, was there?
There was not.
Okay, so your argument is basically the note, and I don't mean to steal your thunder, Mr. Civilette, but the note says no oral modification is allowed. The course of conduct or part performance that the other side relies on is not unequivocally referable to any action or inaction of the plaintiff, and therefore the court was proper to overlook or disregard the alleged oral modification upon which the respondent's argument is primarily, the appellant's argument is primarily based.
Well said.
I'm not looking to make arguments. If I missed anything, let me know.
Please do.
No, but is that generally we got to look at the accrual date, whether it's a good faith basis or facts in the record, I should say, for the oral modification, whether or not that course of conduct should count. So I just want to make sure for both sides that you understand that we're trying to properly identify the issues to evaluate the case.
Yes, sir. I believe there's two different sections to this. Number one is the no oral modification, and then which the court addressed. There were two different summary judgment motions. The first one was
I couldn't figure out what happened with the first one. All of a sudden, there's an order in the middle of the record that says the previous order is gone. But so put that one aside. We're dealing with the other. I think it's a motion to dismiss. What do I know?
Well, just for clarification's sake, the first summary judgment motion was dismissed because the appellant argued that he needed discovery. And so Judge Dillon at that point says, okay, fine, have some discovery. Well, a couple of years went by, we had depositions, we had thises and that's, and everything happened, and nothing further progressed. So then we brought this summary judgment motion, and the two parts. Number one, there is no oral modification that can be proven, no how. There's years of discovery, and it's not happening. Number two, even if, and this court addressed that issue, even if there was no subsequent evidence of any type of waiver that was brought in. The appellant brings up the issue of that meeting on December 13th of 2015. Leonard Aldrich was present. The issue of an oral modification was not even discussed. Now, wouldn't it have been appropriate at that point that if, so it's a fundamental issue.
Which meeting are you talking about?
December 13th of 2015 was a meeting of the shareholders.
Was Leonard dead? Or no, he was still alive then. That's right. Okay, so but I thought the oral modification was based on something that happened in 2010.
Yes, no witnesses to that except the self-serving statement of the appellant. So then we have the appellant was relying upon a December 13th of 2015 meeting of the shareholders. Going back to 2010, unnamed date, etc.
Mr. Sutherland, the course of conduct, I think that has to be relied on here is the conduct by the plaintiff and relying upon the actions of the defendant. All the plaintiff did here, right, was forbear. And there the plaintiff had lots of reasons to do that. First and foremost might be he was a shareholder in the company, that would be the debtor. He didn't want to upset the apple cart with his father, things like that. So I think we have the issues to look at, but if there's something more, for my part, I'm happy to listen, I guess.
All right, well, there was a fundamental issue here as to who owed the debt, because there were two different corporations. The LNG is the incident defendant. There was, in this meeting of 2015, the discussion was, well, I thought it was Vineyard Falls that owed the debt. So there was no clarification here at all.
All right, we'll take a look at that.
Thank you.
Thank you. Last case on for argument is 635 State of New York versus Christopher P. Williams II. Virtual argument.
Your Honor, we have the appellant's attorney coming over. However, the respondent's attorney checked in and has not joined the Zoom session. We did reach out by phone and they didn't answer.
So we'll go with whoever we have. Mr. Mix, good morning.
Good morning, Your Honor. May it please the court, Sean Mix on behalf of Appellant, State of New York. Every appellate division, including this court, has already determined that Governor Cuomo's executive orders told rather than suspended applicable statutes of limitation. Statutes of limitation operate like a stopwatch. When the cause of action accrues, the stopwatch starts and the period of time in which a plaintiff has...
Excuse me.
Yes. Oh, sorry.
Yeah, so basically, your argument is that the governor's tolls for COVID just froze everybody, clock stopped, they resumed later, and that gave the state more time to pursue this, and they did within that period of time.
Correct.
And we have cases, as you just, I think you sent over an additional citation where the parties both kind of agreed to that, and there's other authority in support of your position on the toll.
Correct, Your Honor.
On the second issue, the state's failure to submit a counterstatement of material facts is then required by the court rules. What do you wish to say about that? Because there were two bases for the ruling. One for summary judgment. One was statute of limitations. Another was your failure to submit the counterstatement.
Correct, Your Honor. Well, respondent's statement in a statement of material facts that the state was not stopped from suing Williams from January 4th, 2015 to January 4th, 2021 is really irrelevant to determining the statute of limitations. Whether a plaintiff can file before a statutory deadline is irrelevant to determining the proper statutory deadline. A plaintiff is always permitted to commence an action at any time during a statute of limitations period. The key date is the statutory deadline, and there's no requirement that to receive the benefit of the entire statutory period, a plaintiff must show it needed that full period of time. We also believe that that statement is more properly a conclusion of law, which did not warrant an admission or denial. But in any event, that statement is irrelevant because a plaintiff is generally allowed to commence an action at any time during the statutes of limitations period.
Do we not have cases that, even assuming there were statements of fact, we have case law saying that under the rules as they existed, the trial court is not mandated to deem admitted facts that are not countered. We have a number of cases that say that the court can do it, doesn't have to do it. The defendant here says that it was mandated, and the trial court seemed to suggest it had no option here. Our case law, I think you would agree, suggests otherwise.
Yes, Your Honor, we agree with that.
You're asking us to reverse.
Yes, we're asking you to reverse Supreme Court's decision dismissing the case.
Counselor, if we do that, do the new laws regarding surprise billings by hospitals apply at all in this case?
Your Honor, I'm not sure on that right now. I think that might be something that would be handled below, but I'm not clear on that now. I could submit a letter to that.
Okay, all right. Thank you.
If you would like. Unless there's any other questions, we would rest on our brief.
Okay.
Thank you.
Thank you.
Thank you.